Justice of the Appellate Judicial Court Department. Hear ye, hear ye, hear ye. All persons having business to do before the court will draw near with their attendants and they shall hear.
Thank you. Please be seated. The first case on for argument today is People v. Heverly, case 556.
Good morning, Your Honors, and may it please the Court.
Let's just wait for a second for your opponent to get situated.
I apologize.
No need to apologize. We're all good. Go ahead, proceed, counsel.
May it please the Court, Peter Banishak for Mr. Heverly. I'd like to focus on point 1 in the brief, unless the Court has any questions with regards to point 2. And our contention is that defense counsel was ineffective for failing to move to suppress on the ground that Officer Alger's search exceeded the consent that he was given by Mr. Heverly. The crux of the issue is what a typical reasonable person would have understood from the interaction between the police officer and
Counsel, let me ask you this. We're able to look at the trial, there was trial testimony in this case.
There was.
Yeah, and the officer's testimony goes into the pants were unzipped and a bunch of information concerning the condition of the defendant at the time he was proceeded with the search. Because that wasn't available at the motion, at the time the motion was decided, or could have been brought, was brought but not argued, right? Because there's a suppression motion, but it was not pursued. Is that fair? Okay. So because that wasn't available at that time, are we able to still look at that for purposes of determining whether or not there's, that he should have pursued this and there was a likelihood of success on the merits or not?
I think you could look at Officer Alger's testimony, and because that presumably tracks what was in his police report and roughly tracks what he testified to at the hearing. Officer Alger would have had to testify because it was the people's burden to establish the legality of the search. Whether the court can consider Mr. Heverly's testimony at trial, I think, is a different question, because had the motion been made by counsel, it's not guaranteed that Mr. Heverly would have testified. Counsel could have decided that we don't need Mr. Heverly to testify, it's the people's burden to prove the legality of the search, and therefore the court doesn't consider whatever Mr. Heverly has to say. But my position is that regardless of whether the trial testimony of both Alger, Police Officer Alger, and Mr. Heverly is considered, the result is the same, because in both circumstances, well, for one, Mr. Heverly testified at trial that his consent was for the officer to conduct the pat search. His zipper was already open when he was inside the car, according to Officer Alger. So when we go outside of the car, the officer says, "Can I search you?" And Mr. Heverly says, "Go ahead, search me." He doesn't say, "Go inside my underwear," or anything more intrusive than the typical search. And even Officer Alger testified that his normal search is to pat somebody down and to look into their pockets, perhaps. Here, he went farther than that. And I think any reasonable person, when they're consenting to a search on a public street at 10:45 in the morning, doesn't expect that the officer is going to reach inside their underwear and obtain an item from behind their genitalia.
Yeah, it's hard to argue that last point that you just made. That's not reasonable expectation in terms of what an officer is going to do or should do on a street encounter such as this. But the facts here are a little different, in terms of the defendant's pants being unzippered and the information the officer may have gleaned from, what transpired before then in terms of hands in the pants and information about drugs.
Didn't she
It's
say?
a little different.
Didn't she say he had something in his pants, and then the guy zipped his pants down and say he could search me? Wouldn't a reasonable person distinguish this from an ordinary pat down search and then unzip his pants?
I think that gets into whether we consider Mr. Heverly's testimony at trial, which our primary contention is that we can't consider that in terms of whether defense counsel's decision-making was reasonable.
But is that contention preserved?
It's not, but and I think that's the point, though, that defense counsel was ineffective for failing to preserve it, and.
Well, counsel, let's just focus on the officer's testimony.
Sure.
As you suggest. The officer, according to the officer, when he walks up to the car, he sees the defendant with his hands down his pants. He tells the defendant, get your hands out of your pants. Then he talks to the driver, the officer does. The driver says, referring to the defendant, he just stuffed something down his pants. The officer, now we know from the defendant that he overheard that. The officer then asks the defendant to step out, and then he asks him to search. Given all that, the officer saw him with his hands down his pants. The officer heard the driver say, the defendant just put something down his pants. Wouldn't the officer's request to search necessarily involve a look down his pants? I mean, otherwise, if the officer just pat frisked him, that wouldn't seem to have satisfied the need there to find out if he had something down his pants.
I think I have at least two responses there. One is, Your Honor indicated that Mr. Heverly said he overheard this claim that he stuffed something down his pants. That wasn't Officer Alger's testimony.
Well,
he never.
The defendant yelled at the driver after he got arrested, why would you tell him that? And some other colorful language, suggesting that he heard that the driver say he put something down his pants.
That's true. That was Mr. Heverly's testimony. Officer Alger's testimony, however, was that his Bostic allowed him to search the car. That was the extent of his testimony about what Bostic said. Unless I'm mistaken, Judge, he never said that Bostic told him that Mr. Heverly stuffed something down his pants. But even if that were true, we're talking about his pants, not his underwear. And so the scope of the search should still remain the same. It should involve searching the pants, not sticking his hand into the underwear.
So the distinction is, that's the distinction you want us to draw. In other words, looking inside the pants but not inside the underwear would have been appropriate here, but the line is crossed when the underwear is pulled open and he looks inside there.
It is, Judge, and I would make this point as well. In addition to what the testimony was, in terms of when we look at the case law and what it says about the scope of the search, when officers go further, they either announce that they're going further or they receive permission. So in People v. Meredith, which is a Court of Appeals case which we cite in our brief, the officer specifically asked the defendant to undo his pants, and the defendant willingly did that. I believe it's People v. not Blake, but the other federal case that we cite. In that case, the officer conducted a somewhat more intrusive search, but didn't go inside the clothing. It was just a pat-down search, perhaps a little more firmly in the growing area. But in no case does an officer conduct a more intrusive search without either stating that and not receiving an objection or asking permission to do so, and we have neither of those things here.
I think we have that argument, Counsel.
Thank you, Judge.
Thank you.
Morning, Your Honors. My name is John Tunney. I'm here for the people. The discussion that has just occurred, of course, occurs in the context of a claim of ineffective assistance. And I think I'd like to at least begin by focusing on the strategy that defense counsel adopted in this case. Mr. Heverly was charged with a B felony drug offense. He was also charged with an E felony of tampering, concealing the drugs, as well as misdemeanor possession of narcotics. The strategy here, which, by the way, appears to have been largely successful, was to concede the possession of the misdemeanor drugs, to, I would call it, quibble with the notion of tampering, because in his opening statement, the defense counsel basically said he invited the police to discover these drugs. He wasn't trying to hide them. He wasn't concealing them. He was cooperative. He consented to the search. Yeah, I've got some misdemeanor drugs on me. Well, he didn't say that, but of course, that
Could
that
he
was
have
the-
been consenting because he didn't think they would go into his underwear? And
Well-
that, could have been consenting because he figured they wouldn't see them?
I think he hoped they wouldn't see them, to be sure.
Are they mutually exclusive? In other words, because he wanted to take that strategy at trial, would he not have been able to still run the suppression hearing and made the argument at the suppression hearing?
I believe he could have, yes. And contrary to what the defendant claims, and I believe it was the reply brief, suppression of the drugs found on the defendant would not have dealt with the serious charge that he was desperately trying to avoid. Given Mr. Heverly's age and extensive criminal history, conviction on the B felony, possibly as a persistent felon, could easily have, as a practical matter, resulted in, for him, a life sentence.
I agree with you on that, but if suppression had been successful and the drugs are out, that means tampering's out, the misdemeanor drug charge is out, doesn't that help him on the B felony? If there's no, doesn't it hurt him that he had heroin and cocaine in his underpants when he's defending the more serious drug charge?
What it does as a strategy is remove a place for the jury to go. If he's confronted only with the B felony, the jury's in a yes or no situation. In this situation, the strategy, seems clear from the record, was, let's minimize the downside here.
Well, let's assume that we don't agree that that's a legitimate strategy. Is it a colorable claim of suppression? Because that's what the defendant needs.
I don't believe so.
And why not?
Well, because I think the observations of the officer, given the area in which the activity occurred, the strange, inexplicable operation of the vehicle in essentially a circle, the varied explanations of coming from Rochester to Corning, going back for no particular purpose, the specific observations by this trained DRE officer of Mr. Heverly's condition, supported by Officer Glover and Sergeant McDivitt, who both indicated an observation that Heverly was under the influence, so much so that they were unwilling to work with him. He attempts to trade information as against Bostwick, the driver, and they were unwilling to deal with him because of his condition. It seems that Officer Alger had founded suspicion, which supported his request of the driver to search the vehicle and the request of Heverly to search his person.
What's the effect of the defendant's statement that I can't believe you did that?
Well,
He immediately said that, right?
right, to Bostwick.
Yes.
The effect is to, in part, to acknowledge that he was aware that she had thrown him under it's not a bus, it's a car, that she had incriminated him.
Do I have it right that the officer testified either at the suppression hearing or trial that the driver told him, it must have been the hearing because it's hearsay, that he testified that the driver told him that the defendant put something down his pants? Do I have that right, or am I mistaken on that?
I apologize, Your Honor, I lost the sequence, if you could repeat
Yeah.
that.
Do I have it right? Did the officer testify at any point that the driver, Ms. Bostic, told him, the officer, while they were standing outside the vehicle, that the defendant had just stuffed something down his pants? Do I have that right?
That's my understanding of the record. So it's my position that this notion of the suppression motion, while conceivably certainly colorable, would not have been successful, and that the overall strategy, in the overall strategy, that mattered much less than dealing with the much more serious drug charge.
Thank you, counsel.
Thanks very much.
Case 557, People versus Exford. Proceed, counsel.
Learn this time. Good morning again, Your Honors. I'd like to focus on points 1 and 3 in the brief, unless the court has questions about any of the other points. With respect to point 1, the lower court here erred in refusing to provide the jury with a circumstantial evidence instruction. The trial prosecutor and the trial court relied on 2 pieces of evidence, the State Farm surveillance video, as well as Investigator Stevens' testimony, to say that there was direct evidence in this case. In my view, the respondent's brief at least implicitly concedes that those 2 pieces of evidence are in fact circumstantial, and I think the court's reasoning also shows that it's circumstantial because it indicated that an inference of guilt was possible from those 2 pieces of evidence.
So, assuming we get there, is it harmless error?
It's not, Judge. In People v. Swem a few years ago, this court indicated that in the circumstantial evidence context, harmless error applies in exceptional cases where the evidence is overwhelming. And obviously, I'm in no position to deny that there was evidence pointing toward Mr. Exford in this case, but as we detail in our weight of the evidence points as well as in our harmless error subpoint in the circumstantial evidence instruction, there were a number of unanswered questions in this case that would have allowed fair-minded people to draw different inferences from the evidence. We have no direct proof as to precisely how this fire was started. There's no flammable liquids, there's no accelerants, there's no incendiary devices. We simply don't know. Even the fire investigator had to speculate and say there was probable cause that this was started intentionally by a human being. But the lack of any evidence as to exactly how this fire was started, or that lack of evidence, really calls into question the mens rea with which the fire may have been started. Was it in...
Did you, I would agree that intent isn't exactly overwhelming. There was no motive, apparently. Based on the videos, it seems pretty clear that he started the fire, whether accidentally or not. Would you agree with that?
The video is relatively strong evidence. I think
Right.
that's
So,
fair.
some of the counts, like there's one reckless endangerment at first, which is a felony, arson second. Wouldn't it be harmless on those, the non-intentional ones? And that gets you some of those convictions?
I disagree, Judge. Even assuming that he did start the fire, the intent or the mens rea, whether it was intentional or reckless, depravedly indifferent, I think reasonable minds could differ, whether he was utterly indifferent to what would happen.
Well, he knew his friends were upstairs.
He did.
So if he didn't call the fire department, he didn't do, he didn't seek help. If anything, he knew his friends were there.
That's true, Judge, but again, when we look at how was this fire started, did he know that this would erupt into a conflagration as quickly as it did? Was some sort of small pile of debris set on fire just to alarm or annoy the upstairs occupants?
But if you take a lighter and you light a rug on a wall on either side, you can assume the whole thing's going to burn, can't you?
Maybe, but we don't know that that's exactly what happened. That's certainly a possibility. I can't deny that. But is the evidence so overwhelming that that's precisely what happened, that there's no other reasonable possibilities? I would respectfully submit that it's not. And in terms of his indifference, if he knew that he was setting such a large fire and that this would result, would he come back 10 minutes later, carrying those DVDs that he was about to watch with Mr. Mushtari.
Counsel, I think there's a number of things that give me concern, but I want to kind of drill down on the position you're taking here in argument, and that is, are you conceding that there's overwhelming evidence that your client's action started the fire?
No, I am not.
You're not. And because when I look at the video of, in this case, there does appear to be somebody, or a person presumably, but it's very dark, shadowy, open the door, and then the door closes again. And then there's a very brief period of time, and then it opens, and that's when I think your client comes walking out of the apartment. Would you agree with that interpretation of the video, or do you have a different interpretation?
Judge, I have to honestly say that the numerous times that I've watched the video, I did not see the opening and closing of a door.
So you didn't even see that much, and forget about that there might have been a person doing that. So that becomes that's my concern. My concern is that, one, we don't have overwhelming evidence, I don't think, at least I'm struggling with that concept here, of how the fire got started. But we also have a defendant who is intoxicated and on drugs, walking out the door, and his reaction to the dog on the street and the neighbor walking the dog, the neighbor doesn't see the fire.
I
Right?
agree with that, yes.
Now, there's some idea of a hood or something, and that might have blocked his view of the, but the fire is clearly in the video happening behind the defendant, right?
It is.
We all agree with that.
Yes.
Yeah, that's plain to see. But at what point, are you taking the position that your client knew the fire was started as he walked out the door, or he didn't know?
My position is that the evidence is not overwhelming in that respect.
That he knew?
Correct.
It's not overwhelming that he knew?
Yes, I think that's certainly a fair inference, but I think that there's enough evidence to also infer, to make a different inference about what he knew and what, if anything, he did.
And we're really talking about overwhelming evidence at this point.
That's the only question. We're not talking about sufficiency. Is there, we're not necessarily viewing the evidence in the light most favorable to the people. I think we're taking a neutral view, and we're determining, one, was it overwhelming, and would this critical instruction on the complex and rigorous reasoning process that the jury need to engage in, might that have made a difference? And I respectfully submit.
What about your clients, and some of the other testimony that your client bought lottery tickets, many lottery tickets at the bar right afterwards? How is that to be interpreted?
Judge, in my view, it's ambiguous. He might have been buying lottery tickets because he just escaped death, because he was not up there in that apartment when the fire started. So, in that respect, there's nothing.
And his demeanor once he's back at the scene of the fire, there's some evidence about that. How do you interpret that evidence?
I think that cuts in my favor, Judge. He's emotional, according to Tristan McGrath. He's crying. He can't believe that
He
this
says
is just.
he's sorry. How do you interpret that language?
It could be that he's sorry that he wasn't there to save the two decedents.
So there's different ways to interpret what was happening there. One's innocent, one's guilty.
I think so, Judge, and there's simply not enough evidence. I think if we compare this to the analysis this court conducts in the weight of the evidence context, the first step is does the evidence allow for other reasonable interpretations, and would it have been reasonable for the jury to reach a different conclusion?
Okay, but Counselor, what in the record or what testimony would lead the jury to not speculate and draw a conclusion that there was some other cause to the fire than what the expert testified to?
I think there isn't other evidence that wouldn't lead the jury to speculate, and I think that thus supports the argument that the evidence isn't.
There's nothing in the record to adopt another theory. I mean, there was mention of a possible cigarette, but there was no cigarette found or butt found or anything like that. What could the jury have latched onto that they could articulate as a reason? And instead of, I mean, it wasn't a choice between two verdicts here, or between two choices. This was a theory they had, and there was nothing else. Or was there? Is there something in the record that...
I think there was, Judge. So one possibility is, in Justice Whalen's questions, there was indication we don't know how the fire started. It's possible that if Mr. Exford is the one who first approaches that threshold of the doorway, he steps back inside to light a cigarette, carelessly throws a match behind him, and that lights a fire. There's no evidence to conclusively refute that potential. And with respect to the cigarettes, in our brief, I indicate that Investigator Stevens' testimony is based on a flawed premise in that he says that in order for a cigarette to be responsible, it would have had to fallen in that exact, or he refutes the contention that it would have been impossible for a cigarette to have been applied in the moment the fire, or in the moment before the fire ignited. But he didn't say that it was possible that earlier in the night cigarettes fell from the second story or from the landing on the second floor and were simply smoldering for however long they were smoldering for, and just so happened to ignite the blankets at that moment in time. I don't think Investigator Stevens' testimony conclusively refutes that possibility.
Well, look, even if you're wrong and there is overwhelming proof that he started the fire, there's not overwhelming proof of his intent. You have intentional crimes here, you have, he's charged with other mens rea, as you say. If there's not overwhelming proof on intent, he gets a new trial.
That's correct, Judge. I think if this court finds that there is not overwhelming proof with respect to either element, whether it's identity, whether it's mens rea, or whether it's even actus reus, that which perhaps is all intertwined, then under either of those scenarios, Mr. Exford should receive a new trial.
Any further, counsel?
Judge, with respect to point 3, I'll mention it briefly because I do believe that it is related to the first point in that it somewhat short circuits the jury's fact-finding process. Investigator Stevens, as I mentioned earlier, in my view, offered a speculative opinion in that he's, with no real scientific certainty, simply saying there's probable cause that this was caused intentionally by an open flame. In my view, we can divide off Investigator Stevens' testimony in two parts. The first part being, which I view as scientific. He conducted the analysis, the investigation of the house, and reached conclusions about what the fire was not caused by. So it wasn't weather related, it wasn't an electrical malfunction, it wasn't a malfunctioning appliance. That in my view is all fine. That shows his expertise, that shows his application of his expertise. The second part of his opinion, however, is not necessarily based on his scientific expertise. That's based on both that expertise and a view of all the evidence, including the video, and he thus reaches the conclusion that it must have been a human-caused fire because this person is seen in the video. That second conclusion is squarely within the ken of the average juror. An average juror can say, there's no other causes, we have this video, we have this other evidence, we conclude that it was an intentionally set fire. That, in my view, invaded the province of the jury, and it was not something that the fire investigator was uniquely situated to opine on, and coupled with the error in the first point, deprived Mr. Exford of a fair trial.
Thank you, counsel.
Thank you.
Good morning. Jeff Tompkins for the people. I would have to say that in relation to the last argument first, that the investigator I think what he was referring to there, the way that I read it, was that by the nature of the flame was what he was seeing in the video, not necessarily because of the fact that Mr. Exford was walking away from this flame, but the way I read it was that he looked at that, and that was part of ruling out that it was not some sort of a smoldering event that kind of built up. It was a relatively quick kind of a flare-up.
Counsel,
sort
let me
of
ask
flame.
you about that. What in the record informs the court that of the timing between when a smoldering ignites and how quickly it ignites and how quickly the flame erupts? Is there something that gives us some confidence about the timing on that? In other words, if you're making the argument that if it was smoldering, then that light, the flame we see behind him as he walks out the door would not have been there. Yet, I don't see anything in the record where the expert says it could not have ignited that quickly. And don't fires ignite quickly once they start and burn quickly? Which is why people have to rush out of houses and apartment buildings?
Under circumstances, depending on what it is that's
And we
that's
have
catching
trash in the
flames.
hallway, and, right, and there's evidence about that.
But
We've got flammable rugs hanging on the walls near the trash.
I guess I would have to agree with you that there doesn't appear to be much in the record to support his position, and I guess I would rely on his, being recognized by the court as an expert, not only in this case, but in other cases, in exactly that, directing his testimony directly towards those issues and the start of fires and things of that nature. And I think that, and I can't recall if this was in there, but if it was a smoldering sort of thing, there would have been smoke for a period of time before that as well. But I think all of the testimony...
Is that in the record too? Is there expert testimony about the period of time there would have been smoke in the hallway and the condition of the hallway that he would have been walking through, where it would have been obvious to anybody that that was happening? Is there any testimony from the expert on that issue? I mean, I see you're making the argument, and I think maybe the argument is there must have been smoke, right? But I don't know that there's any expert testimony about what the condition of the hallway would have been as he walked through it, if it erupted promptly after he got to the door. And the operation of the door, you've seen the video many times more than I have, I'm sure. Is there some indication in the video that the door opens and then closes before the defendant then walks through it? Or am I not seeing that right?
No, I think that's correct, and that, but yes, it is, it's not the greatest quality of video, and it is quite dark.
It is not. You can't tell whether that's the defendant or not. I think that's fair to say.
Yes.
When a door opens and air comes in from an open door, we know what oxygen does to a flame, right? And to maybe a smoldering fire, one that's maybe not noticeable. Is that possible, that the door opening and then closing is what ignited this fire?
Well, I don't know if it could be necessarily ruled out, but again, he's taking a look at all of, everything else that was also in the record, including the statements of the witnesses who smelled smoke and immediately realized there's a significant fire. It wasn't a situation where somebody had been smelling smoke for 10 minutes, 15 minutes, or anything like that, and then finally figuring it out. It was all relatively quick.
Did
So
the
that would
expert
lean
address the
towards it.
possibility that the door opening and oxygen coming in because the door opened might have caused something? But I don't remember seeing that in the record. Was there something from the expert on that I haven't picked up
I
on?
have to apologize, I can't recall
I don't
specifically
recall
on
that.
that.
Yeah, I'll have to take a look at that. Okay, thank you. Proceed, Counsel.
No. And to the issue of the jury charge and the circumstantial evidence charge, I don't think that is fatal to the case there was so much other evidence that pointed
Well,
to
Can we
the
just stop you there?
defendant.
Do you agree there was no direct evidence here?
Well, there's some,
Because if there is, then
I-
there's no error at all. We're talking about harmless error
Yeah.
for no need.
I mean, the only thing that I could look at to point to and say is direct evidence, I would, the video is, I don't know if that could be considered direct evidence. What I personally think is some of the better evidence, or if you're going down a scale and you're getting to that tipping point of direct and not direct, the one that's very close is his statement subsequent to the fire when he was in jail about killing someone else. You know, and I understand his frustration, he was in jail, but adding that one word into that, I'm going to kill someone else. I'm not going to kill someone, I'm going to kill someone else.
Don't we have to make some, we have to infer a bit from that statement? We have to infer that he's talking about the fire, and we have to infer that it was intentional. I mean, he could have said, could have been referring to accidentally through a cigarette butt. But that's, in your view, that's the closest direct evidence that we have.
That's
Okay.
as close as any of it's going to come.
But you were going to harmless error then, when I interrupted you.
Yes, I'm sorry. But when you take a look at his behavior that evening, from the first time he was seen coming out of the yard of the apartment building, crossing the street and talking to the gentleman with the dog, and then, based on his own testimony, he went down to Stewart's to get some movies. I wouldn't expect the court to realize this, but the jury certainly did. The house was on the same side of the street as Stewart's, and yet he came out ostensibly to go to Stewart's to get some movies, crossed the road to speak with someone, then headed down the street towards Stewart's. He would have had to cross the state highway a second time to get to a place to get some movies. He was seen by people that he knew, people that knew him that same evening. They were talking about abnormal behavior. He told Mr. Muchler previously that he talked about burning the building. He talked about burning that particular building. He talked to Mr.
That's what gets you to proof beyond a reasonable doubt. For overwhelming proof of guilt, would you agree or not that we need more evidence of guilt for overwhelming than for proof beyond a reasonable doubt?
Yes.
So we could say, yeah, you proved beyond a reasonable doubt, but it's still not harmless, right? It's really, I mean, harmless error is really hard to establish. It's an extra higher burden.
I understand. Yes.
And you think that this meets it on all the elements, including intent?
Well, when you look at everything that went on, the conflicting statements that he made about not being at the house, he told Mr. Muchler, "Oh, I wasn't at the house," but he told other people that he was. I mean, this is all within just a matter of moments. And again, looking at his behavior, sometimes crying, sometimes acting like totally disinterested. He told I believe it was a bartender, Buckingham, that witness testified that he said to her, "I was just up there." And again, Mr. Muchler, it was the exact opposite. You know, his behavior, he was just at this house with all of these people, and while this is all going on, he decides to go to the bar.
Doesn't he also make statements at the bar that is asking people if he smells like flesh? I mean,
That was a very strange question from anyone, yes, but he was asking that question as well. And like I said, you know, his travel path that night, crossing the street, you know, calmly walking away from the house, which was depicted in the video. But then after talking with the gentleman, breaking into a jog and heading down to get his movies. I think, again, when we look at everything that went on, including his statements in the jail, his statements ahead of time about potentially burning down the building, his...
You think that that's
wide-
enough to get us to overwhelming?
I think when it's all put together...
We'll take a look at that, Counsel. Anything further?
No, thank you.
Thank you, Counsel. Case 558, People versus Stewart. Counsel are on video. Very good. Counsel, can you both hear us?
Yes, Your Honor.
Yes, Rob.
And we can hear you. Please proceed.
Good morning. May it please the court, Melissa Swartz on behalf of appellant Mr. Stewart. Unless the court has questions for me on other points, I'd like to focus my argument briefly on point 1A, the jury selection issue, the ineffective assistance of counsel claim, and Mr. Stewart's sentence. In our initial brief, we acknowledge that perhaps this court's decision in Watkins constrains our ability to say that what happened during jury selection was a mode of proceedings error. Briefly, I would just like to make a last pitch that this should be reviewed in the interest of justice, because the trial court specifically stated that this is a practice of his to allow the parties to have this alternating peremptory challenges. Not to go too far a view of the record, but this particular trial court has not been on the bench for very long, and I think interest of justice warrants review of this issue because it is a deprivation of a defendant's right to a fair trial, specifically in selecting a jury. Moving on to the ineffective assistance of counsel claim, I think from beginning to end, defense counsel in this case made some critical errors, and those critical errors were mostly not objecting to some rather bizarre commentary or questioning by the prosecutor in this case. I would be remiss not to bring up the jury selection commentary where the prosecutor stated five different times that he had been plucked out of private practice and is now a prosecutor and he sleeps a lot better at night. Why I think this comment was important to object to and really has no reasoning behind it besides prejudicing the jury is because it wasn't a response to anything defense counsel said. It wasn't in the heat of closing statement where sometimes you say something you don't mean or you say a fact you wouldn't have said. It was during jury selection. It was a pre-planned comment and defense counsel said nothing. So it was this double-barreled denigration of not only the defendant in this case, but also defense counsel in advocating for him. I absolutely think that should have been objected to. The people point out that the defense attorney after the fourth comment, kind of said, I sleep fine at night. I don't think this was enough to undo the prejudice. And I do think it should be looked under the realm of ineffective assistance of counsel. The commentary regarding what I think is inflammatory pieces of fact that were not objected to continued. There is this whole area where people are talking not only about this attempted rape, but Mr. Stewart's sexuality. The people argue that defense counsel tried to use the change in statement from the complainant in this case to kind of undermine his credibility. But where I think that argument falls flat is defense counsel breaking what I believe is a cardinal rule of don't ask a question you don't know the answer to. And that question was, have you ever seen Mr. Stewart with a man, right? And this opened up the door to the complainant say, yes, I did hear he's bisexual. And then the prosecutor kind of latching onto that with a completely separate witness and saying, hey, do you know anything about Mr. Stewart's, sexual proclivities? And that's all in front of the jury, which is, hearing that Mr. Stewart, committed this assault, but also tried to commit an uncharged rape. The prejudice towards Mr. Stewart continued with the conversations about his incarceration. I would agree with the people that some of that would have been permissible because it kind of is in the context. It's interwoven with the statements, right? Where did you meet each other? Where were these statements made? And they were made in the jail. Where I think that proof, kind of expanded beyond something that was permissible and absolutely should have been objected to was the conversations about Mr. Stewart's prior incarceration in Buffalo, in the hole, the commentary by the prosecutor that, they were in SHU, the security housing unit, or as he stated, time out from time out. None of that was objected to, so that painted Mr. Stewart as somebody who had a vast criminal record, but also wasn't able to comply with the rules while he was inside an incarcerated status.
We'll take a look at that, counsel. Anything further?
Just briefly on the sentence, Your Honor, before trial, the court offered 6 years incarceration to Mr. Stewart. After trial, it became 20 years. I don't think there's anything in the pre-sentence report that actually changed that. The trial court noted that he was familiar with Mr. Stewart's record as well as everything that happened in the case. I think at 233%, uppage, I think that's a trial tax that shouldn't be warranted and you should reduce it or modify it. Thank you.
We'll take a look. Thank you, counsel. Counsel?
Thank you, Your Honor. Amy Hollenbeck on behalf of the people. I'll try to start at the beginning and go through in the same order. In regard to the jury selection process, I think I've laid out in the brief pretty clearly what our position is, which is essentially it's not a motive proceedings error, and that there's not a necessity in this particular case for the court to intervene with an interest of justice review and reverse based on any error.
Ms. Halbeck, could I ask you this?
Yes.
Would you agree that there was no legitimate strategy for defense counsel to go along with how the court did peremptories? The lawyer apparently didn't know the order, didn't realize how it was supposed to work.
I would agree, Your Honor, that I can't think of a strategy
Right.
why you would do it that way rather than the way that it was done.
And that could have potentially harmed his client.
It could potentially have, but in this particular case, as a single error, I don't think it did. I think the jury, when you read the entire voir dire and then the challenges on the peremptories and the cause, both attorneys are participating actively. Defense counsel is participating actively, and both are participating in a very professional way. As I think I pointed out in my brief, although defense counsel exercised her peremptories first, I think on 10 occasions, on 7 of them, the prosecution went along with the decision to keep the juror. It was only in 3 cases where the prosecution said, we don't want that juror. So
Right.
clearly the
But you agree-
prosecution wasn't
Right.
abusing their.
But you agree there's no legitimate strategy for that, and the lawyer just made a mistake there. What about the prosecutor's comments during voir dire, repeated comments about now that he's a prosecutor rather than a defense lawyer, he sleeps
Right.
better at night?
Right.
You don't approve of that type of language, do you? Those types of comments?
Well, that would generally not be a part of the voir dire or an appropriate comment during voir dire. But again, defense
So the
counsel's
lawyer should have
choice-
objected. So you would
Right.
agree that the defense lawyer, maybe the first time you could say, well, he's not gonna,
Right.
he doesn't want anyone to focus on that, so you let it go. But second, third, fourth, fifth times and no objections, that rationale kind of goes out the window.
Well, but I think what defense counsel did, and she did this throughout the trial with a lot of situations, is she was thinking on her feet and she used it. And she used it to try to weed out jurors who would think in the same way. And I don't think that that's inappropriate. And if she could, the court would have said to disregard, or she could try, because her point, she's in voir dire now. This is not in an opening or a closing. She's trying to find out who else thinks that way. Who else is going to go along with that? So I don't think it was inappropriate for her to try to use that commentary and essentially, she minimized it. It's not important. It's not what we're here for, but let's make sure nobody else is expressing any bias against my client. And I don't, so as a result, I don't think it was harmful. Excuse me? I'm sorry.
You're saying it was a strategy then, is that your argument? It's by not objecting to that
Yes.
inappropriate comment by the prosecutor?
Yes. I mean, sometimes inappropriate comments, the court instructing the jury is helpful, and sometimes it's just as helpful, I think, depending on the situation, to just go forward with it. Had that comment been made in an opening or a closing, I think that would be different than in jury selection. I think she was utilizing the comment.
Didn't all the jurors who were there for the opening statement, they were there for voir dire, they heard this statement 5 times from the prosecutor? It's not like there was a new group of people.
There's no question they heard the statement.
Counsel, let me ask you this. You just made reference to it might be more damaging if it happened in openings or summation. Didn't he make that reference? And maybe you certainly know the record better than I do, but didn't he make that reference during his summation also?
If he did, I'm sorry, Your Honor, I don't recall it. I'm not saying it didn't happen, but I don't recall that particular statement.
Anything further, counsel?
Your Honor, no, just on the remaining ineffective assistance of counsel, I think, again, I would refer the court to my brief. I think that a lot of the things, there's imperfections, but there's overwhelming evidence in this case of what happened. And in particular, there's overwhelming evidence of the assault and the defendant is the perpetrator of the assault. The references to any attempted sexual activity, I think, again, counsel was attempting to use that to undermine the credibility of the victim, which was her strategy throughout the case, and looking at the facts of the case made the most sense. The victim identified the defendant. He knew the defendant. This happened in the defendant's mother's basement. Really, her only place to go was to undermine the credibility of the victim, that this incident occurred at all, or that the defendant was the perpetrator. So,
Can I ask you one last question? Let me ask you one last question before you go. The sentence, the defendant was offered 6 pre-trial and ends up with 20.
I believe that's correct. I don't dispute that.
So what, and we understand that a defendant isn't going to get the same sentence after trial than from a plea offer,
Right.
but this was more than 3 times. Was there anything that the judge or the prosecution learned at trial that they didn't know when they made that 6-year offer?
I believe that the court specifically referred to the fact that the pretrial offer was much less, and the reason for his sentence was after having observed the trial and the defendant and the victim at the trial, seeing the extent of the trauma to the victim, the extent of the injuries to the victim, and hearing the testimony. So I think that the court soundly explained that its decision was based on the trial testimony, the increase in the sentence.
Thank you, counsel.
Thank you.
Case 562, Williams versus Julie Grau. This has been submitted by the appellant, it appears.
Yes, and I believe the AFC was having some issues with her camera. She sent me an email last night, so I don't know if she's on or not. I
Well,
did see she checked in.
let's hold on a second. We're talking about Counsel Davis, right?
Yes.
Yeah, let's see if we can get Counsel Davis on, or whether we need to recall the case. Thank you, Counsel.
I'm here, Your Honor.
Oh, you are?
Yes, I am, Your Honor.
You're not on our video, but that's fine. We can do it if if you can hear us. We can do this
Yes.
by audio.
Yes, thank you, Your Honor.
Very good. Proceed, Counsel.
Peter DiGiorgio for the respondent. Based upon the appellant submitting, I'll be brief. I just want to highlight that the main issue that the petition did not allege a change in circumstances was not preserved. There was no motion made at the conclusion of each case, and the conclusion of at the end to dismiss it. I believe the petition did set forth enough allegations, and there is case law out there that I cited in my brief that dueling modification petitions almost presume a change in circumstances when there's both sides are alleging a change. And I think a reading of Ms. Kunz's testimony with regard to these parties' inability to parent sustains enough of a change in circumstances. The court weighed all the factors as it should have been and rendered a decision. The standard is that there abuse of discretion, which I don't believe there was here. So unless there's questions, I'll rely on the rest of my brief.
No questions, counsel.
Thank you.
Counsel Davis?
Good morning, Your Honor. I'm Stephanie Davis, attorney for the child. I think there are 3 instances in this record that totally disqualifies the appellate as a joint custodian of his daughter. The first, I believe, is in his, well, frankly, I think he likes good sense and good judgment in his decision to follow the mother on the road without thinking of potential consequences for an accident or injury to his daughter who is in the vehicle with the mother. I think his actions engendered fear and apprehension in her. I think she was frightened of his potential aggressive behavior, which she's noted before. And worst of all, he followed her to her place of employment. And I just find that that's just totally unacceptable. She too called law enforcement on that day, and 3 deputies arrived there at her school, at her place of employment. I think that the record, that his actions afterwards show that he really did care. He just was thinking of himself and what he was being deprived of. And if the mother was punished as a result of that, then all the better. The child was in the vehicle. The child was a witness to all of this. The child was a witness to her mother having to call law enforcement for assistance. And I think that this just inflicted unnecessary trauma on my client on that particular day. The second instance I like to highlight is the appellate's deliberate failure to confirm that he would take the child. I believe it was the 3rd weekend of March of 2022. He had called earlier to cancel his weekend visitation, but then he calls her on a Sunday evening complaining. And again, she says, okay, we can make arrangements for Monday. During this conversation, she had brought up, you need to be mindful of other people's times and what's going on in their lives, and asking him to confirm. That morning before she went to school, she called him twice to confirm whether or not he was going to take their daughter that Monday morning, which was not a regular visitation day. He deliberately refused to answer. And so while she's driving to school, to work, she spots him on the road headed toward her home. He gets there, he's knocking on the door. She sees him on her Ring doorbell. He leaves there. Later, he goes to her mother's home. He's banging on the door of her mother's home. The record says that they all hide in the bathroom because they're afraid of him and they're afraid of his temper. And that's not the end of it. Later that day, he shows up at a senior living facility of the mother's grandmother, and he's banging and pounding on the door. And whatever you may have thought of the mother's actions or inactions, or if she could have done something differently, that still does not excuse his day-long episode of traumatizing.
Counsel,
Yes,
we'll take a look at all of those instances that you've cited. Is there anything further?
The third thing, Your Honor, was his propensity to call the mother's racist names. And that's just unacceptable. Of all people to label as racist. He labeled racist the mother of his child. And I just find that just totally unacceptable. The record shows that he's unreliable. He likes consistency, and he behaves and believes like everyone owes him and he owes them nothing. There is no evidence of how a 50-50 custodial arrangement would benefit the child, only what a 50-50 arrangement would do for him, such as provide him with better housing and, on paper at least, equality to the mother. Thank you, Your Honor.
We'll look at that. Thank you, counsel. Case 563 in the matter of the estate of David Peters.
Good morning, Your
Counsel,
Honors.
if you would wait 1 second.
We're waiting for Mr. Byrd.
Mr. Bird's going to appear by video, and there he is. Mr. Byrd, can you hear us?
I can. Could you hear me, Your Honors?
We can hear you. Okay, counsel. Thank you.
Good
Proceed.
morning, Your Honors. Catherine Grantier Cooley on behalf of the Tonawanda Indian Baptist Church. This is a construction proceeding concerning the will of David Peters. We'll refer to him as David. David went to great lengths in his will. He went to great lengths in his estate planning. We can see that from the length of the will, the detail of the will, the fact that he also creates a business management agreement. And we can see that what he wanted to do, and is typical of these types of businesses on the Indian properties, a smoke shop to continue to provide for his family. He also knew that his family didn't necessarily get along, particularly his daughter and his sister. So he
Counsel,
took...
we're familiar with the record, and,
Okay.
and all that's very clear, I think, upon a reading of the record and the briefs in this case. The question I have for you is, once it's Corinne and Thomas, I believe, that we're talking about as the signatories on the adherence agreement.
Right.
Once their signatures are affixed to that agreement, then it's the management agreement, right?
Right,
Yeah.
they have to adopt then the business management agreement.
Once it was signed, the rights to the assets vested. As I am looking at this, and once that happens, doesn't this impact your client's rights directly, and not in a good way, negatively? And any enforcement of that management agreement would be done in a civil business setting, not through the circuit's court.
Well, I don't believe that simply signing the language of the will itself, the language of the business management agreement, makes clear that David required more than just signing of the agreement. If he had wanted the parties to just sign a business management agreement, he would have stopped at that in his will. Instead, he says repeatedly, however, in the event Corinne and Thomas do not agree and become party. So there's a provision, you have to give meaning to the word and. He required two things to happen. They had to agree and to become party. He also further...
Well, isn't that what happened when they signed the agreement?
It is not. Because if you look at Corinne and Thomas's sworn testimony, Corinne herself says she was never permitted to be involved in the business. She never received any payment.
You mean after the signing of the agreement?
From the date of David's death, Corinne says she wasn't allowed to set foot on the property. She did not receive benefits from the property, meaning any pay. She could not be involved in business decisions.
But didn't they operate it together at least for a brief period of time after he died?
Not if you take Corinne's sworn testimony at its face. Corinne says we never operated the business together.
But didn't she have a right to enforce it after the agreement was executed?
She did, and that goes back to Judge Whalen's question, and that is, if the parties believed that the business management agreement governed, why, and this case has been in front of this court a couple of times, did Corinne go back to Judge Noonan and ask that Thomas be divested of his interest, meaning it be revoked? She didn't follow the business management agreement. She didn't believe that the business management agreement apparently were enforceable. She did not go to arbitration. She did not go to mediation.
Why is what she believed important as far as your argument is concerned? Once the agreement's signed, they're both adults, both have the ability to enter contracts, they both understood what the agreement said presumably, and they signed it. Why does the fact that she didn't believe that it was an enforceable contract play into this?
Because it didn't, if she's the beneficiary of that provision, she's now the administratrix, then she did not believe that it vested, right?
What more did they have to do, Corinne and Thomas have to do for their rights to vest here?
Well, David tells us, if the parties cannot agree on the ongoing business management pursuant to the agreement, it is clear they did not do that.
Right, so ongoing. So what if they agree, they signed this business agreement, and they're working together very well for a year, two, let's say 10 years, and then they get in a fight and they stop? What then? They're not continuously operating under this business agreement. Does it go to the church then?
I would agree that there has to be a stopping point.
Right, but
Okay.
where? Like what day or what year?
I don't know the answer to that, and I don't think this court has to reach that, because if you look at Corinne and Thomas's testimony, they say they never did it. And in fact, Corinne has gone to great lengths to show, and in fact, Judge Noonan did find, that Thomas commandeered Arrowhawk as his own on the same day David died.
Well,
So-
if we're trying to give meaning to these words, ongoing, continuously, it suggests that it has to continue forever. And that we know that that's not possible because people die. It's given a literal reading of those words, it sounds like the church is going to get this business at some point.
I would disagree. I mean, I think, if the estate were closed, right? This estate is not closed. There's been an ongoing fight. That might be another deadline that one could look at, meaning the shares are transferred, the business interests are transferred, the parties have been distributing the funds according to the business management agreement. They have a dispute, they take it to arbitration pursuant to the agreement, they disclose books and records to each other, they make continuing decisions regarding the business together. But so you could say a year, you could say the court, when the estate is closed, when there's a final accounting and the shares are, transferred out. You could pick any number of dates that are reasonable, but here, our argument is you don't even have to get to that question because Thomas and Corinne both testify under sworn oath. And Corinne does it not just in her deposition testimony, she does it in verified pleadings and affidavits to the court, in which she goes to great lengths to say, I was never part of this business. I wasn't allowed to be part of this business. And Thomas says, we never agreed on anything. She's gone to great lengths to sue because Thomas took hundreds of thousands of dollars from the business that she was never able to access. There is no evidence that they did sit down to 2 meetings, I will concede that, but when you look at their testimony and when you look at the meanings of those minutes, they weren't operating the business together. All of the indicia of running a business together, getting payment from the business, sharing in the proceeds, making decisions, being able to set foot on their business properties, being able to access the books and records, none of that is there according to Corinne's own sworn testimony that she swears to repeatedly in an attempt to
We'll take a look at
oust
that issue, counsel. Anything further?
Nothing, thank you.
Thank you, counsel. Counsel?
Thank you, Your Honors. Opposing counsel started off by stating that David Peters went to great lengths in his estate planning and the drafting of this will, and I think that's a key point. If you look at a letter it's the record page 197, but it's a letter from Richard Campbell, who represented David Peters throughout this entire process. And what he says during this letter on October 4th is that there was a potential bequest to the church, but because the parties entered into this agreement, it never vested at all. I think that's the strongest support for what David Peters' intent was. And the court's where I can tell by their questioning of these arguments and our opposition to these arguments. But I think that's a very strong point that I want the court to keep in the back of their minds, that Well, David went to great lengths. The person who would know best is the drafter of this will and his attorney, and he supports the position that the respondents have here. So based on that, Your Honors, and everything that's in our papers, I would ask you to confirm the decision of the Circuits Court that got it right, that this will is clear and unambiguous.
Thank you, counsel.
Thank you very much, Your Honors.
Case 564, Dairi versus Scipionick. Mr. Steinhaus, we can see you. Can you hear us?
Yes, I can, Judge.
Very good, counsel. Please proceed.
Your Honor, the arguments that I am advancing are fairly well set forth in the papers. In essence, I think that what I'd like to draw Your Honor's attention to are the specific facts of this case. No one disputes that my client was approximately 30 feet in the air when the scaffolding that he was standing upon collapsed. The respondent doesn't dispute that at all. There is no evidence to the contrary. I think what's important to realize is that on that particular occasion, my client was only there because the defendant required him to be there because there was an inspection about to take place, and obviously the defendant wanted to make sure it would pass inspection. So under that limited view of the specific facts, you have to take it a step further, and you have to look at the fact that no question, at least on a summary judgment motion, no question the defendant was acting as his own general contractor. No question he sourced the majority of the materials. No question that he hired multiple contractors to do the work, which I should point out, there was no architect, there was no drawings, it was all by word of mouth and instruction. But I think that where the lower court got it wrong, and the reason for the appeal, is because on multiple occasions throughout the record, it was established that the defendant, at least again for a summary judgment motion purpose, lied. He denied hiring the co-defendant George Pacone. George Pacone offered an affidavit confirming that, yes, I was hired directly by the defendant. I was paid in cash by the defendant. Once a person has lied, at least again for purposes of a motion, once a person has lied, a jury then is required to flesh out whether or not that credibility is tainting all of what that person says or not. That was taken from my client. Certainly at a trial on a full record, if a jury were to find that my client did not meet his burden, that would not be impossible. But to remove from him the ability to place it before a jury on these facts, I believe the lower court usurped the role of the jury, and in doing so deprived my client of his day in court. And again, under these set of circumstances, I submit that that was error. I'll rely on my papers unless there's any questions.
We'll take a look at that, counsel. Thank you. Counsel?
Thank you.
Good morning, Your Honors. Daniel Hunter for respondents. The facts are clear here. Respondents fall within the homeowner's exception to Labor Law 240 and 241. There's no dispute about that. This affidavit submitted in opposition of George Pacone, who is a defendant who's never showed up for any proceedings in this matter.
There's a default taken against him.
There's a default taken against him, correct.
And he's the person that brought the scaffolding on the property and constructed it? Do I understand that correctly?
We've never been able to depose him, Your Honor, so we are unaware of anything or of any material facts that he may know about this case. The first that he showed up in this matter is in this opposing counsel's opposition papers. With us not having the ability to cross-examine such a witness, for him to rely completely on this individual statement and saying that respondents are somehow being untruthful, that goes against justice for us to even have to attempt to respond to this.
Was it the plaintiff, help me with the record here, was it the
Sure.
plaintiff's testimony that indicated that Picone was the one, that was Picone's scaffolding and Picone erected it?
The plaintiff did not own or erect the scaffolding. That is correct, Your Honor.
And did the plaintiff point to Picone as the person that was in charge of the scaffolding? It was his scaffolding? Meaning Picone's?
That's my understanding, Your Honor.
Yeah. And so if that's part of the record before us, here's my question for you. Your client, the homeowner.
Yes.
Indicates when questioned, and I think your opponent raised this argument, indicated when questioned that he didn't know, I think it was he didn't even know Picone and didn't know who put the scaffolding up and didn't pay anybody for it. Is that close to what the record reveals?
I don't have the record in front of me, Your Honor.
He denied anything to do with paying for the scaffolding and Picone.
Perhaps, Your Honor, when it comes to Picone, yes.
Yeah, but that was later demonstrated that Picone was involved and was paid. Was it not in the record? That he paid cash to Picone?
That is what's being alleged by opposing counsel, correct, Your Honor?
Okay, and you're saying there's no evidence of that?
That's what I'm saying, Your Honor.
Okay, very good.
Yes.
All right, proceed.
Thank you, Your Honor. The tools were not supplied by plaintiff. The work was not done, by respondents. The work was not performed by respondents. Appellants did all of the work, had no direction, had no supervision from respondents whatsoever. They fit squarely within this exception to labor law, which has been held by this court and New York State for quite some time. Regarding any kind of material questions of fact for commercial purposes, there aren't any. Respondents testified that this has only ever been used as his residential home. He is a local radio DJ. He does have a DJ business, but he did not have any recording studio or any type of at-home work.
Well, even if he did, the exemption would still apply. It doesn't have to be solely for commercial purposes?
That's correct.
Like, even if he lives there and he works there, then that's not good enough.
That's correct, Your Honor. And also with this exception, the work would have had to been for that commercial purpose. This work was a laundry room addition over a garage.
And plaintiff didn't point to, I'm looking at the record, plaintiff didn't point to any specific conduct by the homeowner relative to directing and controlling the work.
That is correct, Your Honor.
But plaintiff did say that the homeowner moved the scaffold at one point, did some work. I'm looking at the 200 claim.
Sure.
And Picone's affidavit as it pertains to the 200 and the common law negligence claim.
Well, again, Picone, we have not been able to depose. There's a default against him.
And did you, but did you try to subpoena him?
We've attempted to get Mr. Picone to be involved in this, correct?
Did you subpoena him?
Not that I'm aware of, Your Honor, no. So for the 200 claim, a 200 claim would fail if there's no direction or supervision of the work, which there is none. And Mr. Dairi's own testimony when asked if he ever saw plaintiff move the scaffolding was that he did not believe that he did, was that he did not recall that. So there was a self-serving affidavit that was submitted with opposition papers from Mr. Dairi, which said that he may have seen respondent in the past move the scaffolding, but that goes in direct controversy to his prior testimony.
Anything further, Counsel?
That's all I have. Thank you so much.
Thank you, Counsel. Case 565-07 versus Fleming.
Good morning, Your Honors. May it please the Court, John Bonsbach for Plaintiff Respondent, BL 07. On July 26, 2024, this Court, including, I see, 3 of the justices on this morning's panel, issued a memorandum and decision unanimously affirming Judge Sciano's decision denying the same school district's motion for summary judgment in the related BL 04 case. Both that case, BL 04 and the instant plaintiff respondent, BL 07, were abused by the same school district teacher, Edwin Fleming, in the same 1980 to 1981 school year.
So your argument is that there's no difference relative to this case concerning our prior cases, and we should hold the same.
Yes,
Thank you, counsel.
you're welcome.
Case 567, Renzi versus Renzi. Justice Kane is recused on this case. Counsel, proceed.
Good morning. May it please the court, Jennifer Lorenz, on behalf of the appellant husband, Thomas Renzi. I know this court is very familiar with the facts of this case. This is the second time your honors have had the benefit of seeing this matter. I'm assuming the first time you saw this case, you thought to yourself, why didn't the trial court list the factors for why they went above the maintenance cap? Why do we have to send it back for an explanation of the factors? Well, now we know, because there are none. The subsequent amended decision doesn't provide any further clarification or justification for exceeding the maintenance cap so significantly in terms of amount and duration. None of the factors provided is listed in my brief, either individually or collectively, justify going so above the maintenance cap.
Can I ask you about the term of maintenance? The guidelines call for basically 9.5 to 13.5 years, and the court went 14 years here, right?
Yes, and interestingly, the trial court states that it directed the husband to pay maintenance until he reached the age of 67, and then comments, it's a range of under 10 years based on the lengthy marriage. The trial court...
That's post-judgment though, right? So you're arguing that he was paying temporary maintenance since commencement, and we should add those years in?
Yes, and he should be credited for that.
Is there
those
case law
maintenance.
on that particular issue? Because we see this a number of times.
Yes, I believe that there is, that any duration of maintenance is credited from...
Wait, no, I understand that, but as far as, the statute talks about post-divorce maintenance, uses the word post-divorce in the Domestic Relations Law 336, when they're talking about the term. So is there a case law that says, even though it says post-divorce, meaning after the judgment, we count back to commencement?
Yes, I believe that there is case law that you can count from date of commencement, especially if it's from a preliminary conference order. It's an order from the court, and it is post-commencement. Yes,
Okay.
absolutely.
But those are advisory, I mean, it's not mandatory, right? You can go longer or shorter if justified.
Yes, it's certainly discretionary, and I would...
Here it's like 6-7 months longer than the range under the statute.
Correct. Correct.
So not that much longer as far as the term, but you're challenging the amount as well.
Yes, I mean, in this case, the court, after this court sent it back, did go through probably 5 or 6 factors, none of which are supported by any evidence in the record. For example, the court says that both parties are in good health. Well, the testimony, it's undisputed the wife was in good health, she testified to that, but the husband specifically testified that he wasn't in good health, that his health was deteriorating, he had been recently diagnosed with multiple sclerosis, that he was treating with UBMD. There's also a factor which I think is very bizarre about how the wife had to take care of her elderly father, and somehow that was a factor in the maintenance determination when her testimony said that her, along with her seven siblings, were helping her father. And it's my belief that he passed away months before the divorce.
I agree with you on that point, but on the husband's health, his MS diagnosis, was there any evidence that affected his ability to work at the time of the trial? In other words, I get maybe long-term there's going to be some problems, but had it yet affected his ability to earn?
I don't think there is evidence that at that point it did, but my point is if it's a factor to go above the cap, if it's a factor to say, you know, in essence there's a maintenance calculator. The purpose of maintenance is to, for the recipient to become self-supporting and also to generally maintain a certain standard of living. Presumptively, that's included in the calculator. The calculator shoots out a number. That's the essence of maintenance. So presumably, that's already included in there. To go significantly above or beyond the number from the calculator and have one of the factors be like, they're in good health. How is
They were
that?
currently in good health, I think the court was saying. They both were able to work. I think
Right,
is
so,
what the
so
court was
how is
saying.
that a justification to go above the maintenance cap? She's in good health. If he's presumably in good health, there's indications that maybe down the line he wouldn't be, but how is that a factor to go above the maintenance cap? Certainly, there's nothing preventing her from assuming full-time employment. At the time of trial, she had been back in the workforce for 16 years. Yes, for a period of time, she stayed home with the party's children, but she was back in the workforce a significant period of time. And I think a lot of emphasis was on the fact that she gave up her career to stay home with the party's children. But again, that was 16 years before this trial. And there's no dispute here.
He didn't allege that he couldn't afford to pay it, or that it was a hardship in any way. Did he?
Certainly, I don't.
She was 61 and he didn't allege any problem with that.
With all due respect, I don't know if a hardship is a standard for, his ability to pay maintenance. I really think there's no dispute she was entitled to maintenance. Absolutely, she was entitled to maintenance. We don't dispute that. But again, we go back to, there's a calculator for a reason. And
your point is, there need to be factors justifying going above and outside the calculator.
Absolutely, Judge.
And you're saying if we look at the record in this case, such as health, they both have good health, well, fine. Why is that not a presumption that the calculator is supposed to go above it? That's your point. And the other what other factors are you saying that do not argue for going above?
I think the biggest factor in this case is that at the time of commencement, the presumptive amount was $4,000. The wife had accumulated over 2 years, almost $80,000 in a savings account that was primarily her maintenance payments. She testified that she owned her home as part of an interim agreement that they had during the divorce. She secured her own house. She did not have a mortgage. Her only expense that she testified to was a lease on her car. In her brief, she argues that, yes, my house was significantly less expensive than the father's, but she chose to live a more frugal lifestyle. That's certainly her choice. But I think the biggest piece of evidence is she clearly demonstrated an ability to be self-supporting. If you're not using your maintenance payments every month to help you either maintain your standard of living or help with your general expenses, and you have the ability to put them in a bank account and have them accumulate up to $80,000 just in 2 years. At the time of trial, the presumptive amount was $4,500. She would have even gotten more than that.
What did she have by way of retirement assets?
That
She
would have
was
been-
older and she was closer to retirement than he was, as I recall.
Well-
What did she have, if you could refresh my recollection?
I don't have that specific information in front of you, but again, she was awarded equitable distribution. There was other assets that were divided. Part of that was a residence that she didn't have to pay a mortgage on. So, and one of the factors that the court says in its justification was that defendant had also dissipated some assets. There's no specificity. Well, what assets? How much were they? How does that factor into this? Certainly, if there was assets that were dissipated, that would have been something, that's an issue for equitable distribution.
I'm trying to, your argument's interesting, and I want to kind of ask this question. If the wife was accumulating these payments in anticipation of the date when those payments would stop and she wouldn't have income, so that she could then use that income, that accumulation, to live off of, would that not be a reasonable financial approach, to the extent that while she could earn to pay her expenses, save those for future expenses when she could not earn? And isn't that a reasonable approach to this?
Certainly.
Economic situation she finds herself in?
Oh, certainly, Judge. She can choose to do whatever she wants with those payments. I'm saying if we get to back to the bare bones purpose of maintenance, is to be self-supporting and to maintain a standard of living. Clearly, she's achieved and has demonstrated during the 3 years that this case was pending that she achieved that. She achieved self-sufficiency. If she chose to put those in a...
How about maintaining the same living standards?
And part of me, maintaining the same living standard is kind of a legal fallacy. You have one household.
Right.
You have two people sharing.
It's going to be hard. Both have to drop a bit.
Right, that now you're going from one household and sharing expenses to two households, two different expenses. And again, she says in her brief, I chose to live a frugal lifestyle. That's certainly up to her. We go from $4,000.
When your client moved out of the, if I understand the record correctly, both parties moved out of the family residence and your client moved into a new residence. How did the new residence, in terms of value and square footage, compare to the one he left?
I believe that he chose a house that was comparable to the marital residence. Well, the wife voluntarily chose, to secure a residence that was less in value. And again, as she stated, she chose that because she chose to live a more frugal lifestyle. She chose that. And again, this is not a situation where I'm debating whether maintenance was appropriate. Of course it's appropriate. It's the level of going from what the calculator determines. There's a presumptive amount that's appropriate. This is not a situation where this woman had a debilitating medical condition and significant medical costs that would justify going over the cap, or a disability that prevented her from earning any additional income.
But she's 61 years old. She has no Social Security. She has nothing. She'll have to live on this because he is paying within the range. 11 years is within the advisory range. And
well, I mean, this is also
within the
interesting.
Discretion of the judge.
Well, and this is what's also interesting, because the judge says the husband will pay until he's 67, when he can reach full Social Security. She is 5 years older than him. She can elect to take Social Security when she is 67. He will be 62.
But if she didn't work, what Social Security is she going to take?
She can elect to take his. She can elect to take his if he's not.
She gets half of his, and his remains what it is. But
right.
If she takes it at 67, and he's only 62, he's eligible, but he's not eligible for full retirement.
Right.
Does she get half of, when she's 67, half of the lesser amount of his Social Security, or does she get more by waiting until he gets to full retirement age?
I don't have an answer for that, Judge. I do believe that she can take it without a deduction.
Right, it's a question of how much without
Right.
a deduction. Yeah, but your point is valid, that at 67, she's going to have more money coming in.
Right.
But she might have more money if she waits beyond 67.
And I just think that the presumptive amount, she showed in the 3 years that this case was pending, that $4,000 a month was more than enough to be self-supporting. At the time of trial, the presumptive amount was $4,500, so she would be getting an extra amount. And to go to $5,700, based on these factors in this amended decision,
We'll take it, Counsel, we understand the argument. We'll go and take a look at those factors and we'll analyze them ourselves, but we understand your argument.
Thank you, Judge.
Thank you, Counsel.
Good morning, Justices. Kelly Farron for Donna Renzi, the respondent in this matter. The lower court did not abuse its discretion in going beyond the presumptively correct amount of the maintenance guidelines as far as the amount. I agree with Justice Ogden and the calculations that some of you set forth, that the length of maintenance is not beyond the guidelines suggested formula. It's well within the guidelines formula.
Well, not if you count temporary maintenance, and counsel says there's some case law, but what factors to deviate upward on the amount of maintenance, what factors did the court rely on? Because she makes some good points with respect to health. That doesn't seem, if they're both in fine health, as has been said, that doesn't justify upward departing.
I would respectfully disagree. It could. He's in good health. That means he has a long lifespan. He has the ability to work.
Well, he's diagnosed with MS.
He's diagnosed with MS, but
I think the common analysis, the MS Association is not on the record. 10 years after you're diagnosed, 70% retire because they can't work anymore.
Well-
So if we affirm, okay, hypothetically, I mean, doesn't that like give you the opportunity to come back and they move to modify? You say, well, they knew he had MS then, there's no change in circumstance.
Not necessarily, because if he does have a change of circumstance, he could move to
What's the
modify.
change in circumstance? That now
That-
his MS has progressed, which was foreseeable at the time.
I don't know that it was foreseeable at the time, because this gentleman was not under doctor's care. He was not taking regular medication. The record does have proof in it that Mr. Renzi testified himself that he runs 3 miles a day. He also runs on vacations. It didn't interfere with his lifestyle whatsoever. It didn't interfere with his job. He has a desk job with limited mobility. He doesn't have to. He can work at home. He can work at the office. So
But it's a progressive disease. So is there a dispute that he's diagnosed with MS? Is that your?
There's, in the record, there was no evidence other than Mr. Renzi's testimony that he had MS. Okay?
But don't the guidelines presume good health on both sides? When they
It
set these
does say
presumptive amounts, they're
the age-
assuming everybody's in good health, right? So.
I don't know that they're
doesn't-
assuming that, because the guidelines say age and health of the parties. So the fact that he's in good health, he has no documentation before this court other than his testimony that he has an MS diagnosis. He didn't provide prescription medication that he takes regularly. He doesn't go to the doctor regularly if it's.
All right, so what else besides health justifies going above the guidelines?
The present and future earning capacities, the lower court cited of the parties. Mrs. Renzi went back to work when the youngest of the 4 children entered kindergarten. Prior to that, she was employed full-time, long before that at Gold Dome. And she also did some teaching as far as like yoga or exercise classes. When she went back to work as a teacher's aide. It's really considered like a part-time position because she testified that she does not get pay for when the children are off on vacations. She had limited earning capacity. I think it was less than $19,000.
So that's a factor in maintenance, but is it, and I'm not saying it's not, but it sounds like what you're saying is that's a factor to deviate as well, to say down the road, even though the presumptive amount of maintenance is X, we're going to give X plus because one party's future earning capacity is greater than another. That's a reason to
That's a
deviate.
reason to deviate. Also, the fact that Mr. Renzi was earning approximately $300,000 at the time of trial. And huge disparity. It sets a limit to consider, but then what do we do with that income after? So everyone who is a substantial wage earner gets off at the same, is cut off, and the wives generally who might stay at home, or maybe it's the reverse when the husband stays at home. When you have a high wage earner like that, they're reduced to less than a pre-judgment standard of living, pre-divorce standard of living.
Right, so his standard of living is going to more closely mirror the standard of living during the marriage than hers. And he's making $300,000, he has to give her $5,700 a month. He's not.
Absolutely. When you look at the bottom line in the court's decision, with her earnings and the maintenance award, she has about $87,000 a year, where he has $231,000. And again, these are going back a few years at trial income levels. Even post or pre-divorce, he was able to keep that standard of living because he bought a 3,300 square foot house at a high price, hundreds of thousands of dollars. Mrs. Renzi chose, or she had to choose because she was living off of the temporary maintenance, a 1,000 square foot house. I think it cost $160,000. So she is nowhere near the pre-standard of living. And I don't disagree that sometimes when you have to go into 2 households, the money has to be divided. But he's living in a 3,300 square foot house. She's at a 1,000 square foot house. She's still doing her teaching. He's still doing his financial planning and advising.
What about him going to age 67 instead of, say, 65, where I know Social Security has raised the age, but a lot of people still like to retire, and some are required. I don't know what his firm's requirement is that he can keep working.
It didn't have a maximum age or a minimum age that he had to retire. His firm does not have that. I believe that the trial court went to age 67 because that is full retirement for people of, born in the 60s. That would be full retirement age to get your full Social Security benefit. So again, to answer, I think it was Judge Lindley's question about the retirement, or maybe it was Judge Whalen, I'm not sure. But she has basically limited retirement. Her retirement is going to be a portion of her New York State pension off her income of $19,000 when she retires. Judge Grisanti divided that pursuant to the Majoskis formula between the parties. So that's what she has. He had a little bit, maybe $230,000 in retirement funds in his firm that, again, have to be divided. But that is what she's going to be left with is...
What other, did she get assets from the marriage?
The only asset that was divided for equitable distribution was the proceeds of the marital residence. There was still a mortgage on that, but they both received some proceeds. She used most of her proceeds to buy her $160,000 house. There was no other, aside from the maintenance, which is support, there were no other assets excuse me, that were divided between these folks. The other factors that this court considered was the dissipation of the assets, meaning the tax returns. When you look at the record, although Judge Grisanti doesn't set it forth in his decision, when you look at the record, he did take, I think, 2 years, 2 to maybe 3 years of tax return money. It was significant, over $10,000 each year of tax return money that was refunded to the parties. The court also did decide, factored in costs of medical insurance. The standard of living, I think, was really an important one that the court looked at here, and the income, the great disparity of income. The fact that she gave up her career. She raised 4 children. As the facts in this case state, it was not an easy marriage, I might say. There was a lot of tension. There was a lot of care for certainly one of the children that he basically left all to her. She helped with his career. These are all very important factors as to why a court should consider the income over and above the cap in deciding the maintenance award.
We'll take a look at that, counsel. Thank you.
Thank you very much.
Case 568, Broughton versus County of Onondaga.
The last one.
Your opponent has submitted, as you know,
It looks that way, yes.
so proceed.
Thank you, Your Honors. May it please the court, Karen Felter from the Smith-Sovic office on behalf of defendant attorney Steve Williams. Unless the court has any opening questions for me, I'd like to just focus specifically on one, the heart, essentially, of our appeal. It appears to me from review of our brief that there were some arguments addressed to the merits of the plaintiff's complaint. However, I think I'd like to clarify that the only reason to focus on the merits of the claims against Attorney Williams is that the plaintiff alleges that Mr. Williams intentionally, willfully, and maliciously refused to interview him, failed to interview him before closing his investigation, and did so in some sort of effort to assist defendant Fitzpatrick in his re-election efforts.
Well, the claims against Mr. Williams weren't appealed.
The
Right? We're dealing with with your clients moving to disqualify the whatchamacallit law firm,
Bousquet.
Bousquet, oh, yeah, thanks.
Yes.
I was thinking Green and Cipher, the Holstein, right.
Correct. So the disqualification motion by Attorney Williams was very important here because of the nature of the complaint that is made by the plaintiff against Attorney Williams.
But
And that is,
isn't Mr. Broughton's claim against Mr. Williams that, not that he didn't interview him, because those facts are undisputed. We know that that didn't happen. And there's a lot of evidence as to emails and so forth as to why, I guess Mr. Bruton came up sick on the day he was supposed to be interviewed. The allegation is that Mr. Williams, the reason that Broughton wouldn't agree to be interviewed was that he wanted his personnel file from the county, I believe it was. And that Mr. Williams intentionally did not want to give that over because he didn't want Mr. Broughton to come in to be interviewed. That seems to be the issue. Am I right there?
yes, and I think that that's the allegation in the complaint.
Right.
However, the evidence that was submitted in support of the motion for disqualification was not just an allegation and a complaint. It was a specific attestation by Attorney Williams that he didn't have control over turning the county employment records over.
I agree.
And that the plaintiff, Broughton, agreed to be interviewed without the production of those records, and then more or less inexplicably refused to reschedule the interview after it was canceled. And his attorney never responded to Mr. Williams' request to reschedule the interview. And the reason for it being canceled when he had agreed to appear without the requested documents wasn't really explained. So I think that in the context of defending the plaintiff's claims against him, when the plaintiff alleges that he refused to interview him and did it for some malicious purpose, you know, the fact of the matter is that there's no explanation by the plaintiff as to why his attorney did not follow up and make a request for the interview to be rescheduled when it was requested by Attorney Williams. And I think that that's important because it shows that there's another explanation other than the one being offered by the plaintiff for the refusal to appear for an interview. And Attorney Ordway, who was representing the plaintiff during the time of this investigation, has information, obviously, concerning the reason why there was never any response to the request for the interview to be rescheduled. And the attorney that is now representing plaintiff in this case, Attorney Levine, is from the same law firm. So when the plaintiff testifies at trial that, you know, there was this malicious effort to preclude him from being interviewed and refuses to acknowledge that he was offered multiple opportunities to interview and then never followed up.
I think those facts are going to be undisputed.
Right.
I don't think Bruton's going to dispute those. And
Right.
the question here is whether his testimony on this issue is necessary, not relevant. I agree it's relevant. It has to be necessary for disqualification. And the issue again is, did Mr. Williams, the demand, the refusal to turn over his personnel file, that's really what the claim here is, that he intentionally withheld this so that Bruton would not agree to be interviewed. I'm not sure Bruton has any knowledge on that issue of why, and I'm not suggesting Mr. Williams did anything wrong here. I'm not suggesting this lawsuit's going anywhere, but that's the issue, is whether Bruton's testimony on that issue is necessary.
Well, I'd like to sort of clarify that the issue is whether the attorney's testimony is relevant on that, correct? So the attorney was having discussions with the plaintiff about appearing for this interview on October 29th.
Yeah.
And notwithstanding the request for the documents, that interview was scheduled. So everybody knew there was no documents that had been turned over, and yet the interview was scheduled.
Right, I guess, yeah, you're right, it's the lawyer's testimony, that's it. But what would the lawyer have, how would the lawyer testify? How would he have any knowledge about why Williams failed to turn over personnel file?
Well, I think that certainly Steve can testify that he had no control over turning over these personnel records and that he made multiple offers to the plaintiff to appear And while at first he was refusing to do so because of the failure to have these documents in his possession, he later then, through his attorney, did agree to appear for the interview.
Yep.
And then it was canceled, and then Attorney Williams reached out to him, his attorney, again, and asked for it to be rescheduled, and there was never a response. So I think that that is important because it goes to the credibility of the plaintiff's allegation that there was some malicious intent in, not conducting the interview in the manner in which the plaintiff now claims that he was demanding it be conducted, and also the fact that notwithstanding the opportunity to reschedule this interview under any terms, I suppose, that he wanted to, he never did so. So that is a direct defense and rebuttal to the claim by the plaintiff that, Steve did something wrong.
But this is all about, what's in front of us here, once again, is about whether the Bosque Holstein firm should be disqualified.
Correct.
And it's an abuse of discretion standard of Judge Gilbert.
Correct.
So how did Judge Gilbert abuse his discretion by finding that the attorneys couldn't add anything to this, Mr. Broughton not testifying?
Well, so there's one thing I think that's important, which is that the court held that Attorney Williams had not put forth any substantive testimony that could be offered by Attorney Ordway. And I think, as I mentioned, that is incorrect because Attorney Ordway was the person who was conducting the communications with Defendant Williams about the terms of the interview, whether he would be interviewed, his willingness to be interviewed, the multiple opportunities he was given to be interviewed.
But aren't you almost begging for a violation of attorney-client privilege because you're going to be talking about the communications between Mr. Broughton and Mr. Ordway?
Again, however, that is, the plaintiff's credibility concerning whether he actually was demanding that he be given these records as a precondition to be interviewed is at issue. Because in fact, he agreed to be interviewed without those records. Additionally, when Attorney Williams reached out and requested the opportunity to reschedule this canceled interview, there was no follow-up by the plaintiff or his attorney. So again, Attorney Ordway has information, factual information, concerning why the plaintiff didn't show up on October 29th, why there was no effort to reschedule, why there was no response to Attorney Williams regarding rescheduling. So those are important issues. They're factual that go to the defense of this claim that there was this malicious intent by Attorney Williams. And the fact that Mr. Ordway could potentially be put in that situation is the direct result of the plaintiff choosing another lawyer from the same firm to represent him in the actual litigation that followed this investigation.
Counsel, we'll take a look at that. Anything further?
No.
Thank you,
Thank
Counsel.
you.